Whatever you don't want to fill out. So
to catch this real quick.
Session. I think everyone's still joining.
So I'll give it another minute or so to make sure.
This is Marcy.
All right, I think we've got everybody in that was in the waiting room. So welcome to today's Get Real session. I'm Tiffany Thornton. I am an associate attorney at Martinez Law, and today I'm your guest speaker in place of Ms. Martinez, the firm owner and principal who normally hosts these sessions. So to kind of jump into things, I am going to be discussing a very cool, to me, legal topic that our firm has been encountering recently. If you're not familiar with our firm, we are a full service real estate law firm located in Lutz, Florida. And I am, of course, not the only employee. There are several of us here who work very hard for our clients to make sure we get them the results that they need and the results that they deserve. A lot of our work is with realtors and persons who are professionals in the industry. But of course, we work with individual homeowners, renters, and other persons as well. Today, I'm going to have the presentation that I speak through, but at any time, you can feel free to raise your hand on the Zoom call, put a message in the chat, or just jump in. This is a discussion session. So if you want to just interject with a question, you can feel free to do so at any time. And it's an open conversation. We'll also take questions at the end. I just had 2 more people join, so I'll make sure that they're in before proceeding. All right, I think we've got everybody in, so I'm gonna go ahead and share my screen. By the way, this is also being recorded for us to post on YouTube later on. That way, if you want to rewatch any part of today's session, you can. All right, and go ahead and make sure everyone's in. There are still people coming in. Okay. Let's get started. Okay, I am assuming everyone can see my screen, and if you cannot, that someone will jump in and interject. Today's topic is short-term rentals, the good, the bad, and the ugly. Again, I'm Tiffany Thornton. I'm associate attorney with Martinez Law, and if you just joined, I am the guest speaker for today instead of attorney Martinez, who is enjoying her vacation right now. So the primary good, and you know the bad's coming, but I want to start with the good. The primary good is, of course, a Florida vacation. And just in case you guys aren't seeing my full screen, I am going to hide all these side parts. Florida is, of course, a year-round vacation hotspot, and that's probably why all of us live here or do business here. It's a great place to be, right? Of course, the profitability of short-term rentals is significant and the market is growing. I think all of us know that, especially those of us who are professionals in the field. Along with that, there's hands-off marketing and hosting available through the use of the online host platforms. We all know which ones those are. There's also some informal ones that persons like to use as well. The main benefit, though, is that these keep the marketing and the hosting easy. So you can go through these websites. Good morning. Welcome to the presentation. When it comes to marketing and hosting, your use of the host platform is going to make that easy for you. That's a good, that's a plus. Oops, let me make sure we've got everybody muted for today. I don't want to create a situation where everybody can't hear me. Okay, I think we're good. Also, with short-term rentals, they are a great introduction to investing and property management. They're a good introduction to the business in general. And that's because you can stop at any time, you can change your strategies, or you can go ahead and build further. Meaning that if you have one home or one condo, one unit, you can switch that up at any time. You can choose to make that a long-term rental. You can choose to just wait for a moment and not rent it out at all. There's a lot of options with that that are different from some other investment strategies. Also, the investment cost itself might be minimal compared to a long-term rental, meaning that with a long-term rental, you might be having to pay for a lot of advertising. You may have to do some things to make the home custom or the property custom for the person who's going to be renting it. You may have to invest to get a lease agreement drafted. If there is something negative that happens in the property, you may have to invest in a lawyer to get that issue taken care of. Whereas with a short-term rental, you may already own the property and just be able to turn it around and put it on a website and start earning money immediately. Of course, the bad and the ugly are coming, right? Liability is the invisible elephant in the room that we're dealing with. And it doesn't have to be scary though. That's why I use the elephant, because they're known to be kind of gentle or intelligent at least. And so we're going to talk about it through that lens. The bad and the ugly, as a lot of people know, come down to liability and incidents and things that are going to potentially cost money to the property owner. There's two main types of bad and ugly, and that would be injuries, which can be broken down as negligence-based or premises liability-based, but also in property damage, which is one I think a lot of people don't think about. And that's typically going to be negligence. The responsible party is also very interesting because it could be a big group. It could be the property owner or the apparent owner, which is a interesting piece we'll talk about. It could be the host platform itself sometimes, or insurance has the question mark because it's one that a lot of people think is one of the responsible parties, but that's kind of a toss up, and we'll walk through these things. Before we walk through though, I do want to take a brief moment to see if there are any questions about what I've discussed so far. And again, if there are, just jump right in. All right, another admit. Okay, we'll keep rolling then. So the types of injuries that we see, and I want to kind of preface this with going ahead and telling you where I got this list from, because it's a long list, right? I got this from the website of a local personal injury attorney, someone who is actually advertising basically how to sue your Airbnb hosts. That should tell you something about this market in the flip side. And what I mean by that is a lot of us, like we just talked about, are very excited about the profitability that a short-term rental can bring. But you also want to remember that something that's bringing profit, something that's hot, something that's a good investment, there's going to be a flip side to that, in that there's going to be ways where people are looking for resolutions. People are looking to find liability. And that's what's happening here. So again, this isn't my list, actually. This is one that I found from someone else doing research about the other side of this issue. So just running through the list: injuries, trip and falls, structural collapses, dog bites and animal attacks, falls, a lot of which are from faulty furniture, fires, electrocutions and burns, swimming pool accidents, mold exposure, bed bugs, criminal attacks and harassment. And now I want to kind of talk through those. I think a lot of us think about slip and falls because we've heard of those, but who would think of a trip and fall? Well, rugs, right? Uneven tile, uneven carpet, things that you wouldn't see that literally trip you up. Structural collapse, it doesn't have to be the whole house comes down on the person. It could be as simple as a portion of the ceiling, there's a water leak and it collapses onto that person. It could be a big painting. You notice that in our office, these paintings are behind a credenza because if it falls, it's probably not going to strike someone in the head. However, if you've got big mirrors, big paintings in a home and they're not hung up properly, or you have a large television mounted to the wall and it falls off the wall, well, that's a potential injury and area of liability. Similarly with dog bites, you know that there's a dog that roams the neighborhood that animal control has been trying to find, and your home doesn't have a backyard or doesn't have a backyard fence. Falls from faulty furniture are, I think, one of the least thought about potential issues. You run to the local big box store and buy some furniture to go in the home because it's temporary and it's just for people who are going to be staying there for a few days. Well, did you put it together right? Because if you're missing a screw somewhere, you didn't put it together the way the instructions say, and someone sits upon it and collapses, that is a potential for liability due to their injury. Fires, electrocutions, and burns. Is the home electrically sound? Because if not, someone goes to use an outlet and it shocks them, that could be an area of liability. Naturally, fires as well. Swimming pool accidents are probably one of the more significant in terms of how badly they could harm someone. In this area, we're thinking about things like people not having a child fence around the swimming pool, the steps or the handles that you're using in the bars to get down into the pool not being properly installed. If there's something slick on the surface such that someone slips into the pool and that person cannot swim, things like that are what can open up the area for injuries and naturally for liability. I say this is a big one because obviously in a swimming pool, there could be a drowning and that would be a death and that would be significant. Mold exposure is one that can cause long-term injuries, of course. So you want to make sure the home doesn't have any moisture issues or any pre-existing mold that someone could breathe in and make them very ill. And if that person, say, is predisposed to being sensitive to mold, that doesn't matter. What matters is that they got the exposure. When it comes to criminal attacks and harassment, I think that's one that is somewhat natural to consider, but everyone doesn't consider the way it actually manifests. So if you have a property, and this sometimes goes towards premises liability as well, and you know that there's been a lot of card thefts or a lot of robberies or attacks, and one of your guests actually does suffer that, well, that's potential for liability for the owner of the property if they know that that is happening. So that's something to think about, and that's mainly going to be in that area of premises liability. Is there a known danger in the community that's been occurring? And
someone is a beggar. Yes, he is. He's a beggar.
I think we've got to get everybody muted. Make sure you can hear each other. Okay, alrighty. And then everyone can still jump in if they have a question. Property damage is the other big area. So thinking about someone's vehicles. If there's a big palm tree outside and for some reason it comes down, or let's say an oak tree, that's probably a better example, it comes down on their car. You didn't get that oak tree trimmed. Well, now you've got an issue because their car got damaged. Their personal items in the home. That can turn back on premises liability as well, because let's say that it is a burglary or a robbery and their personal items get taken, that could be an issue. Electronics too. So a lot of times we don't think about turning back to the other areas of liability. If there is a mirror that falls off the wall and someone's phone is sitting underneath that mirror and it becomes damaged, that's an issue. Not just them getting struck by the mirror, but the fact that their personal items could be damaged as well. Same for clothing and jewelry. Clothing and jewelry typically, not so much jewelry, but the clothing come in when there's been water damage to the property. And there's potential for liability in that respect. Last year, this happened in my family. We had a bad leak because our upstairs neighbor had something happen with their washing machine. All that water came down, soaked through my mother's closet, and all of her clothing was damaged. So these kinds of things do happen. Souvenirs, they're coming to Florida, they're going to our theme parks, they're going to our beaches. They probably have some souvenirs. Some of those might be expensive. And so same idea there. Lastly, pets. I know this is awkward. None of us think of our pets as property, but legally they are. So again, big mirror, God forbid, falls down on Fido. We've got an issue. The value of Fido is now in play. Same for his medical expenses as well, his or hers. Responsible parties is probably what you're thinking about now that I have put all of that out there. Who could be at fault? Primary responsible party is going to be that property owner or a parent owner. A parent owner comes in a few situations. One of those, the big one that some people do or don't think about, is rental arbitrage. The process by which someone is actually a renter themselves, but they are subleasing that space out to another party on a short-term rental site. Another area for parent ownership that comes up somewhat commonly and somewhat awkwardly is, let's say your family member or friend has a vacant home and they're entrusting you to be the one who puts it on the short-term rental site and you're splitting the cash or something like that, a parent ownership. And lastly, in the situation of actual business arrangements, let's say that you have an arrangement by which one person actually buys the property, is on the deed, et cetera, but another person is the one actually doing the hosting, a parent ownership. Because the reality is the person who is paying to use the property for that amount of time, if you're the person they're interfacing with or you're the person they can reach, then you're the person that they're going to come to for liability. And the law is going to let them do that to some extent. Next is the host platform. I think that in almost every instance of potential liability or injury, people first think of the host platform. And I mean that on both sides. So there will be persons who get injured or have their property damaged who feel that the host platform is going to be at fault. That goes one way. And then similarly, the actual homeowners or host will think, well, my platform is going to be responsible for this issue. The reality is that, again, owner or parent owner is the primary responsible. The host platform is actually secondary. Where that comes from is the terms and conditions or terms of service for actually using the platform and for that person when they actually sign up and pay to have their stay through the platform. So a lot of times there's actually waiver language. I've personally reviewed the language within 2 major host platforms, terms and conditions. There's waiver language in there saying it's not their fault if things happen. It is possible to reach them if they did something wrong. So I like to kind of flip the inquiry and say, well, what did they do wrong? And then go from there. So if it is truly the host platform's fault, there could be liability to be found by them. And it has happened in court, but for major issues and for specific issues. So, things like the host platform knows that there have been several complaints about this property owner or this host, and they continue letting that person list properties for short-term rental on their site. Well, maybe they're responsible for incidences that flow directly from that issue. One of those big areas would be the issue of having home cameras or reporting the person that is actually staying at the property or the group that's staying at the property. If the host platform knows that, and they know that danger could come from that, they know that person's watching the guest for bad reasons, and they continue letting them host on there, maybe that's an area of liability if that host then takes action and does something bad to the guests that are staying at the property. But generally speaking, it's going to be along those lines where you get the host platform involved. Not to say that if someone wanted to sue, they wouldn't list them as a potential defendant, but the property owner or parent owner should always be thinking that they're the primary person responsible. I want to flow from here to insurance, but first I want to see if there's any questions about the items that we just discussed. So I'm going to give a moment, and if anyone has questions before we move forward, just jump in.
I guess you're probably going to cover this, but how do you go about limiting your exposure or limiting liability when it comes to personal property, et cetera, damages and liabilities?
Good question. And you're correct that it's coming up, but since you mentioned it, I'm glad to jump in now and just give a little preview of it. Insurance, the one that's on right now, is just one way, but the other way is going to be dealing with how you title the property. The reality is that you're never going to fully reduce this liability. You're never going to fully stamp it in the ground and get yourself all the way out the picture, but there's some really good tools that you can use to reduce it. And I see Nicole's iPhone raised hand. Nicole, do you want to go ahead and jump in with your question?
Oh yeah, hi. Yeah, I had to drive, so I couldn't do the Zoom meeting on the computer. Okay. So I've done Airbnb for a while. I have a few questions. One is if the host is the main owner and they're showing on the Airbnb account as the main owner, but then they have a second person helping managing or co-host. They used to call it co-host, and I think they still do, like a property manager type situation. You're still saying that that person would have apparent ownership even if the main host is still the main person responsible? Like, is that the way to avoid apparent ownership, to have the main host on the account?
Good question. So first I want to make sure everyone's muted before I answer, make sure no one's lingering. Okay, I think we're good. Should that person actually, I think it's Georgia. Let me fix that for you. Yeah. Oh, I can't fix it. Okay. Georgia Bickford, I think you're unmuted, just so you know. Just don't say anything you don't want us to hear. with regard to the issue of one person versus the other person being involved, there's actually a few subcategories to that. So I'm going to say for your protection, yes, assume that whoever is involved could have liability and could be named if there's any lawsuits to be had by virtue really of you working together. Practically, could it work out that way if the injured party simply doesn't know that those other persons exist? Yes. So it's possible that if you have person A is the one whose face is on the site, person A is whose name is on the deed of the home, whose name is on the LLC for the business, person B is kind of a silent partner. It's possible that the person who's injured doesn't know about person B and doesn't come after person B. However, legally, could they? Yes. So it's kind of an area where the practical and the legal separate. Because legally it's there, my recommendation is to assume that everyone involved is going to have liability, especially when it comes to business arrangements and partnerships. You know, if someone's name is on that company, if someone's name especially is on that property, and or if you have separate agreements with each other that define that you're going to both be involved in the business, that liability could come at some point. Because the reality is, if a lawsuit is filed, you're at some point, if it doesn't settle very, very early, you're going to engage in discovery, meaning you're going to be turning over information to each other. And business records are normally one of the substantial things that get exchanged. So I would expect that somewhere in that process, the existence of that silent partner is going to become known if it hasn't already. And then at that point, that injured party would have the right to actually amend their lawsuit to include that person as a defendant. So I would always assume it's there, essentially. Oh, I see one message in the chat. Okay, it says they would need to have a good PI attorney that will do the research of all parties responsible one way or another. Correct. And that's essentially what I was just talking about with discovery. So they get their attorney, they get to about the discovery phase in litigation, those matters get exchanged, the documents get exchanged, and that's going to be the point where they find out. The way to prevent that would be to settle the case very early on, which is going to be linked in with kind of where I'm headed next with the presentation to talk about that process. So I'll go ahead and truck along. Great questions. Insurance. Insurance is kind of the it's the baby elephant in the room, right? The homeowner's insurance. Well, a lot of us might already know that homeowner's insurance has business activity exclusions. On that issue and definition, I'm just going to say, don't argue with me, just come down the road with me. Short-term rentals are a business activity. That's not my definition. So that's why I say don't fight me on it. It is the insurance company's definition. It is the law's definition. So we kind of have to work with it. Now we can kind of skirt it here and there. If you end up in an incident and you have a lawyer defending you in that incident, they probably will have arguments that you're not really running a business. Those are kind of sub-arguments. Those are arguments that are made for the sake of being made. They're not winning arguments. So be aware of that piece, first of all. Secondly, we have short-term rental insurance is becoming more and more popular, and that makes us very happy because that's closer to what you need to protect you if there's any incidents. The one that we hear about very often in our consultations and discussions with potential clients is umbrella policies. And candidly, the conversation usually goes like this. I have an umbrella policy, so I'm good. Again, this is not Tiffany speaking. This is the law. This is the insurance company's outlook on things. No. Umbrella policies first have a specific function and way that they work. Umbrella policies kick in when the primary insurance coverage is exhausted, or when it has partial applicability, or when there's some finagling there such that the person's not going to be made whole on the primary insurance. So now we go to the umbrella. Remember what an umbrella is. It's something you put up over you to hold off the rain. It's not primary coverage. So that can become very tricky. If someone has an incident at your property and you say, hey, here's my umbrella policy, go ahead and make a claim. Well, if you haven't already opened one with whatever your primary policy is, or if you haven't started that conversation with your insurer first, you cannot send that person directly to your umbrella policy because your umbrella policy at that point, the insurer has the right to deny that claim for that alone. Could they entertain it if they wanted to? Yes, but that is within their discretion. So the big message that Attorney Martinez and I tend to put out there with regard to insurance policies and your reliance on them to protect you is this. The insurance company wrote that policy. The insurance company interprets that policy. The insurance company sold you that policy. So if you come to them with a claim or with an incident that you want to be paid, they then interpret that policy that they wrote to say whether or not that claim is covered. I know people have varied views on insurance companies. Some people don't really like insurance companies, but for that reason, I am a neutral party in that respect, but I do have to put that element of it out there to you. So I would say read your policy, but it may not make a whole lot of sense to read. I would say go to your agent, which is a great idea, but remember your agent is not the one who's going to be interpreting the policy if a claim is open and if it has to proceed. There's a claims department of the insurance company who do that. So don't make the mistake of thinking that the insurance company is working for you, or that if you bring a claim to them that they have to pay it. That is in their discretion. So it's on you. And if your client is instead the one that is, if your realtor and your client is the one that's going to be renting the home out, remember that piece. They're not like us. They're not your lawyer. They're not your realtor. They're not any of those parties. You send it to them and they decide whether or not to pay it. So it's a decision, personal and business decision, how much you want to leave up to chance with that. I recommend you have it because a lot of times they do pay, especially if it's a small instance, but have the right kind and tell them what you're doing. You know, don't rely on homeowners insurance and your homeowners insurance doesn't know you're doing short-term rentals. Don't go get some big commercial policy and they think you're doing 1 year, 2 year leases with people, but you're doing short-term rentals, because all you're doing is opening yourself up to issues in that respect. So I know that's a big piece and a lot of information, but it's important to think about. With regard to the host platform, this is one where a lot of people want to similarly point back to the host platform, to the website where it all started. They have liability insurance programs. I think a lot of people are using those now. Those are generally bodily injury and property damage coverages. So think about the list that we just used, but let's launch from here and start thinking about what it doesn't cover. Because we've seen kind of the list of things that happen to people, but now let's compare that to what actually can be paid out. I took this sample exclusions list directly from the exclusions list of one of these major host platforms website. So these are real. Aircraft, interestingly, auto and mobile equipment. So when we talked about trees falling on people's cars, that's not going to be covered by the host platform's insurance most of the time. Assault and battery. So we talk about crimes committed in the area and things like that, not going to be covered. Premises liability, probably not covered. Communicable diseases, that applies obviously to a lot of diseases. I don't think it was ever truly tested in the courts whether COVID was one of those, so we still don't know. Contractual liability. So that comes into play if you have a contract with someone else, and then that person is who was injured, or the result of that contract is what brought upon the injury. So workers present in the home would be an example, or things those people have worked on. Electronic data. So, the mirror falls on the laptop is broken now. They lost all their data. Was there a value to that data? Expected or intended. If you've ever dealt with an insurance issue, you've probably heard that phrase. That goes back to your negligence as a host. So if you hung the mirror wrong, you laid out the tile yourself and now it's got cracks in it, you put the furniture together in a poor fashion, that's not coming back to the host platform, apparently, under their exclusions. Exterior insulation is an interesting one, probably more relevant outside of Florida. Liquor is an exclusion. They have some built-in language about what it means, but I'll tell you from my reading of it, it's not 100% clear. So if alcohol was a factor in the incident or the injury that occurred, you need to think about whether or not that's going to be covered. One major issue would be obviously if you're providing the alcohol, which is tough, right? We might, if we know that all of the guests coming are 21 plus, we may want to leave a bottle of wine. If it's a couple on their honeymoon, we may want to leave them a bottle of champagne. Well, if their consumption of that then follows with an injury, could we be liable? Yes. Wrongful eviction. We'll kind of get to that one a little bit later too. Asbestos and watercraft. So, you let them pull their boat up to your dock. You let them park the boat in the yard while they're staying there as a short-term tenant. Not going to be covered if something happens to that boat. Lastly, from what I'm reading in their fine print, they are often not the primary coverage. So turning back to the issue of, say, umbrella policies and things like that, they're writing in that they're not primary. So if you have another form of insurance, they're probably, if you're trying to make a claim with them, they're probably going to turn it over to your insurance first. I believe that recently there have been some forms where the host platform will assume primary coverage from some research I've done, but again, I would not assume it. It is limited to the time of stay, which is interesting. It sounds like, oh, that's fine. Well, you know, let's say that the gals that are down here for the bachelorette party are supposed to be leaving at noon on Sunday. It's exactly noon. They prop the front door open with a suitcase while they're bringing their stuff out because they're running a little late from Saturday night. Well, if it's 12:05 and they're still bringing items out of the home and they trip across the platform again because of whatever they consumed Saturday night, we've got a problem because it didn't happen at the time of their stay. So host platform's not going to assume responsibility for that. And then lastly, the usual limit is $1 million, or in some I found $2 million worth of coverage, which is good. But it means that a lot of people think of wrongful death and very catastrophic incidents on the property as, oh my gosh, that's not me. That's got to be the host platform has to kick in something for that. No, they're putting caps on it. So that exists. Again, I know this was a lot of information. So before I keep rolling forward, I want to open the floor up for questions. And again, just hop in or raise your hand or send a chat if you have them. Scary subject, I know. So we'll keep rolling on and we'll see if you have more questions later. So I've made a little chart here to show, oh, I'm sorry, was that a question? No? Okay, we'll keep rolling. After an incident with insurance, so I've made this flow chart to kind of talk through the pattern of what can happen and that we're going to have without insurance next. So I've made 3 basic patterns, does not encompass everything, but again, it's basic to give you all an idea. So let's talk through them. Pattern 1 is, and I'm not representing that any of these are optimal, by the way, just that this is the way things happen. Any one of these outcomes could wind up being better for the property owner or the persons involved. In pattern 1, you have an incident occurs. There's property damage, there's a personal injury. Next, a claim is opened with the insurance company. Then the insurance company pays the person, they walk away, everybody's happy. Maybe you're not happy because your policy is probably going to go up in the next year, but everyone walks away, everyone's fine. That's one area that can happen. I expect that to happen with smaller, cheaper injuries, so to speak. I don't expect that to happen with the catastrophic injuries, to be honest. In that respect, it's kind of like car accidents in Florida. Pattern 2, an incident occurs. Claim is sent to the insurance company. So far, so good. Insurance declines to pay. This is a big issue. So it could be a matter of the terms of the coverage. The insurance company says, no, we're not obligated to pay this because this doesn't fall within the terms of our policy. This isn't even something we cover, is one way that can happen. The second way it can happen is if the insurance company says, you sprained your ankle and now you're asking for $2 million. Denied. That's another way it can happen. I think I muted it. It's before proceeding. Let's see, who is it?
Hi, this is Walgreens, located at the northeast corner of
I'll show the group video and get everybody muted. Technology is fantastic, right? Okay. Rachel Jackson, I think it's you. Let me see if I can mute you. Okay, I'm gonna mute you just in case it's you. If it's not, I'm sorry. But we wanna make sure everybody can hear each other. So talking about insurance declining to pay, basically 2 main reasons that could occur. From there, different things can happen. The victim could negotiate with the insurance company and say, oh, I'm sorry, I claimed $2 million for my sprained ankle. Instead, just pay my medical bills. That's gonna be like $5 grand. It's accepted, everyone moves on. Or the victim says, okay, I don't want to fight this. I'm done with it. I don't want to be bothered. I'm just not going to get payment for this injury. I'm going to move on with my life. I'm going to let my personal health insurance cover it, or I have funds to cover it, whatever the case may be. And no one hears of the issue again. That's another way things can be resolved. Again, is it better or worse for the homeowner or the person who suffers the injury? It's unclear. It's circumstance by circumstance. Pattern 3, an incident occurs. A claim is sent to the insurance company. Insurance declines to pay. Instead of, and let's say 2 things can happen. They could negotiate, negotiations fail. They could let it sit for a little bit and then come back. But in any case, instead of something being resolved here, the victim files suit against the homeowner and or the host platform. So now we have a lawsuit. This is probably what everybody feels. There's a lawsuit out there. It's got to be resolved one way or another. It's either going to be dismissed or it's going to be settled, or it's going to roll to trial and some party or the other is going to be receiving liability allocations from that. From there, it depends on how things went. So with insurance, it depends, because your insurance company, when the lawsuit is filed, they could choose to assign you a lawyer, which in a lot of cases will happen, to defend you in the case. The lawyer works for you, but they also work for the insurance company. It's kind of weird. If you've ever been in a car accident or been the person who caused the car accident, you may be familiar with that system. So the question is, when the settlement offers fly, does the person bite on one of them if there's insurance, especially if the insurance company is the one putting that offer out there? Are they going to bite? A lot of times they do, because what will happen is once a lawsuit is filed and insurance is involved, they will actually bump it from the claims division into the litigation division. And a lot of times they'll increase their offers at that point and the whole circumstance will change. But let's say that person still isn't satisfied, or they want to go to trial, or you want to go to trial on the issue. Well, at that point, you're rolling forward, you're dealing with a full litigation matter. Again, does it make it all the way to trial day? And is there a trial had? It depends, but it is possible for that to happen. Now, this is the important part of that. If it goes all the way to the end and there is ultimately liability found by the homeowner, there is a judgment had, at that point, still the insurance company could choose to pay that judgment, because the terms of the policy will say, we pay judgments that are within, basically that are within the policy terms. So they could pay it, or they could say it's not, and we're not going to pay it. And then there's a judgment out there. And we're going to talk about what those look like and how to avoid that piece as well, because there is a way for most people to avoid that piece. So I'll take a pause here just in case there's any questions about my chart. Okay, so I'm going to open up my main screen share.
If the insurance declines, can you sue your insurance company?
I think I heard, if you have the policy, can you sue the insurance company, like if they don't pay?
Yeah, can you sue them if they decline to pay? I mean, like the homeowner.
Yes, so that is possible. If they decline to pay, you can go out and hire a lawyer to determine if you have a cause of action to actually sue the insurance company to pay or to reimburse you for payment of a judgment that results from a injury lawsuit or property damage lawsuit. You can do that, but you're going to find out pretty early on whether or not that's going to work, but because the lawyer who evaluates it with you can tell you. Those are tough claims to make. Those are tough causes of actions to maintain against the insurance company, because generally speaking, the insurance company, once something rolls that far to a trial case, they're going to have made a pretty good assessment of whether or not they should pay. And they generally do pay if it's under the policy. So if they don't pay by that point, chances are it really is not something that's covered under the policy. Obviously, there are lawyers out there who do the work of suing insurance companies. So there are times where it isn't. But I would never enter the situation thinking that that would be the result. If there's a judgment and they don't pay, I would assume I'm kind of stuck with it. Good question, good creative thinking as well. All right, let's move forward to without insurance. Again, whether or not this is scarier depends on the circumstances. So the first one looks a little bit similar, right? The incident occurs, the victim is going to send the bill to the owner or send the invoice or whatever they think is going to be the cost to the owner. And the owner pays it. The owner says, okay, I've got a couple $1,000 to pay for your sprained ankle. And yeah, I did mess up that tile. That's why it happened. And everyone's happy. Everyone goes away. Asterisk here, as a lawyer, I'm going to recommend you have a lawyer involved in that process if that's the result, because we would want to have a settlement agreement made. Secondly, incident occurs. Victim sends bill to owner. Owner declines to pay. It's a common one. From there, the owner might negotiate with the victim to get them to accept a lower offer. And that may happen in one direction or the other. You say, no, I'm not paying you $2 million for your sprained ankle. And they say, okay, fine, I'll take $2,000. And you go ahead and give them that and they accept it. Or you say no, and they go on about their life and they go on uncompensated. Either of those things can result. The last one, you can see where it's headed. Incident occurs. Victim sends bill to owner. Owner declines to pay. From there, victim can file a lawsuit against the homeowner and or the host platform. And from there, it looks very similar to the insurance path. So what you should know in this respect, we're going to talk about, again, a little in just a minute, how to deal with that potential liability. But when it comes to the litigation, it's definitely going to be against the homeowner. Maybe they'll pull the host platform in. Maybe you can keep negotiating once it's filed, but at that point, you need to go out and hire the lawyer to defend yourself. And that's going to come at your own expense. And then if they settle with you, perhaps that could work in your favor. But again, that's your personal funds being used to settle, being used to pay attorney's fees and anything else. Or if the person it rolls for it, the person actually wins and they get a judgment against you. Again, your personal funds being looked at to satisfy that judgment, because it's going to exist. It's going to be, we're talking about Florida, it's going to be in Florida, it's going to be on the books. So it's going to be attaching to your assets at that point. So a little bit of a scary path, but again, it depends on how things are structured. It depends on the business deal in play. One asterisk that I do want to talk about with regard to all of this litigation discussion is that personal injuries in Florida have a 4-year statute of limitations. So when I start talking about getting an agreement with that person, if you go ahead and give them a little bit of money, the insurance company is definitely going to do it if they give them some money, is to stop that from happening, because there's 2 issues here. The person could have a trip and fall in your home during their stay, say nothing about it, but go get medical attention, say nothing about it for 2.5 years. You think everything's fine. Next thing you know, out of the blue, you're getting bills. Out of the blue, you're getting a process server at your door serving that complaint on you for the lawsuit. So long as they have actually sought medical care and tried to deal with the issue and incurred expenses in that regard, or there's a medical record somewhere that says that they need this treatment, but they, for financial reasons, couldn't undergo it, but that record is there, they can come to you at year 3.5. You can defend what they waited 3.5 years, but they still get to file that lawsuit. So keep that in mind. It's only going to be barred once it's past the statute of limitations. All right, I'm going to pause again for questions. All right, I know this is the not very fun part. This is a little bit better. It's going to start to look up from here. So let's talk about the judgments and satisfaction of them. Obviously, the worst case scenario for the short-term rental host is facing litigation that results in a judgment against them, because like I said, it's your personal assets that could be levied for this. You have a judgment on the books, you have a judgment in the public records, you have a judgment on the court records. So that could come up in any respect of your life, in any aspect of your life. Even worse, judgments will turn into liens and garnishments. So if that property that you have is not homesteaded, and someone has a judgment, it's going to attach to that home. So when you go to sell that home, that lien's going to have to be satisfied from the proceeds of the sale. If, again, it's not homesteaded, that lien could potentially be foreclosed on the property for them to go ahead and get the money that they are due, because at that point, it's been adjudicated, they're due that money. It also, of course, can turn into a garnishment. So if you have income up to a certain level, it can actually be taken to satisfy that judgment. And that can apply with many other forms of assets. You can let your mind run wild into what that can turn into. It can become very bad. Of course, as we've discussed, insurance may or may not pay a judgment. So we don't want to make that assumption from the beginning. But here's where it starts to look up. The crucial component is how title is held to the property. So let's talk through that. And this goes into how we can avoid some of these issues, but of course not all. Individual names are the most dangerous. That's mostly what I've been talking about here today to make sure you're aware of it. If the property is held in a person's name, then of course that person is who's going to be facing or included in the judgment. So going back to the business partner example, if the property is held in the name of one person and then we have another person hosting, I'm going to expect that both of you are going to be on that lawsuit. If it is a much more closely consolidated, and let's say it's a married couple who are doing this as kind of a side income for themselves, I would expect both of the names to be on the lawsuit, because the owner of the property where the property damage happens is the person liable. Now let's flip that a little bit. Let's say, and I'm going to skip down a bit, let's say it's not a person's name. It's an LLC, or it's a corporation, or it's a land trust. And Florida Land Trust is our firm's favorite option for short-term rentals. I'm going to tell you that now. We have generated a lot of them for new and old investors in the state of Florida, and we are very proud of that. Sometimes it is actually the best and the better option. Let's start with LLCs and corporations. How do we deal with that aspect? Well, one thing we can do is make sure the property has been claimed into the LLC or the corporation, or maybe up front you were able to purchase it so it closed and there's a warranty deed with the LLC or corporate name on it. Fantastic. That means that that is the owner of the property and that's who bears liability. But let's take it a little bit further, specifically with regard to the LLC. The LLC has an issue whereby the corporate UL can be pierced. Corporations do too, but it's more common with LLCs. If there's been commingling, if there is a single member LLC such that when the court looks at it, they're going to say, this is a shell, the person and the LLC are really the same thing. You should expect either that up front, the lawsuit is going to name the individual persons affiliated with the LLC, or that again, in that discovery process, in the litigation, the person who suffered an injury is going to find out that the LLC is really a shell. You should expect individual names to be brought in at that point as well. So that's why we like the Florida Land Trust option, because that doesn't happen with the Florida Land Trust. And the Florida Land Trust, you claim the property into the land trust, and the land trust functions by itself essentially for 21 years, because a land trust is really an estate planning tool in Florida. It's just fine to use it for business ventures such as this. With that, the way it works versus an LLC is that you have beneficiaries, not people who are holding ownership interest. So that person, not legally, but for practical purposes, is the owner of the property, and there's a trustee managing the property. With the ones, for example, that our firm does, we serve as trustee for probably 99% of them. So that means that if there's documents to execute, we actually sign them for the beneficiaries. Beneficiaries don't have to sign. I recommend to people who take that option, who are still using short-term rental platforms, take your name off of that site. Take your name off of everything. The only people that should know your name are obviously your mortgage company, the property assessor's office, title company, or your realtor if you're looking to sell the property, your lawn guy, the person who's cleaning the property between visits, but absolutely not the tenants in the property. That's going to protect your anonymity, which is the next thing we're going to discuss. But that is an option to get all of this off your back, because the distinction, if it's an LLC or a corporation and the judgment is against essentially the property where the incident happened, is that the owner is the LLC or the corporation, right? Well, now your LLC has a judgment against it. And there's possibilities that the person files a collection lawsuit then to seek collection from the LLC. So that's a whole lot of information, I know. So I'm going to go ahead and open up for questions again, because I know that's probably a curious topic for some people. Show my grid video. Okay. I don't see any hands raised. Oh, I see a chat message. Let's see. All right. Seems like LLC isn't really providing any protection. Well, I have a nuanced view on that. You probably don't want the entire legal view, so I'll cut to the chase with it. The LLC provides you the protection that the Florida statutes say it provides, which I think the issue is people think it provides more than the law actually says that it provides. I think sometimes people have been made to think that because of things that are out there in social media or things that are commonly talked about at, investor talks and conventions and things like that, where there aren't lawyers there telling you how it really works. It provides you protection if you use it the right way. So if you are maintaining separatism from that LLC, you have a separate bank account for it, the insurances are in its name, you're not commingling, you're not putting out there that you own the property instead of the LLC. It's really a holistic thing where you have to make sure you maintain that separation. If you do that, then it will protect you, the individual, the member or the manager, in the sense that that liability is not going to flow to you if you don't do those bad acts. And I don't want to say bad as if it's always bad, because it's innocent to wake up at 2 a.m. And call the plumber and pay them with your personal credit card because you're trying to make the guest happy. But the law doesn't like that. That's the distinction. So you get that personal liability, but you're not going to escape the legal liability for that business, because again, it wouldn't be you, it would be the business that has a judgment or that has money assessed against it. So you're protected, but it isn't. That's the way to think about it instead. So you're getting some protections, but I just don't think it's what everyone thinks it is. Good question / comment to have, though. It's an important thing to think about. All right, hearing no more, I'm going to go ahead and roll forward. Local ordinances. I want to chat about this because I think very few people think about it. County and municipal ordinances can apply in Florida when it comes to short-term rentals. It's a new area of law in Florida, and it is constantly changing. Some counties have put out ordinances and then months later put out a revised one. So what do? You keep up with it. Preferably you hire a lawyer to help you keep up with it. It is the property owner's responsibility to comply with them or be fined. And it does not matter if you do not know. That is not going to be an excuse. You've got to keep up with it. The unpaid fines and fees, if they're assessed, will turn into a lien on the property. Now, I want to talk about this part because there is this trickle of investors down to Florida, which I think we all love it. The challenge is if you have a fine occurring on the property and you reside in another state, you're going to be getting mailed that information. But let's say you're not catching your mail. They're not going to come bang down your door if you're in Arizona, you're in California, you're in Georgia, you're in South Carolina. They're not going to come bang down your door to tell you that you're not complying with the code, you're not complying with our ordinance, you have fines and fees accruing month by month. They're not going to do that. So you have to be mindful of what address you're putting down and just be mindful of the fact that these things exist, because ultimately, if they're not paid, they're going to turn into a lien on the property. I think we all know that the state or the county or the city, if they want to foreclose a lien, they will. If they want to take action, negative action with regard to a lien, they will do so. I want to run down some examples of requirements. These are actually from Miami-Dade County, for example, but other municipalities, counties, and cities are putting out similar ones. Licensure, a designated responsible party. So there has to, going back to people out of state, there actually has to be someone in the vicinity that can be reached if there's an issue with the property. And you have to actually register that, going back to licensure, register it with the county. A certificate of use, again, goes back to licensure. A maximum occupancy. So you've got to look at that ordinance and see what it says about the number of bedrooms versus the number of people and make sure you comply. Sex offender and predator searches, that is a rising area. So if you have a home that's, for example, right by a school, right by a park, there is actually some ruling and some cause to say that you should be making sure you're not letting offenders into the home. Pole safety and fire extinguishers, that's becoming a popular requirement, again, of course, because of drownings and fires. And conspicuous notices. So if there's essentially warnings to be had, you will need to post those. I recommend all of these things, except for, of course, license or certificate of use, because those come from the municipalities. I recommend that you on your own enforce these things to be safer. One of the things that our firm will do, if you have a hazardous activity, such as a pool or waterfront home, things like that, big oak trees in the backyard, waivers and notices, put people on notice of things that can hurt them, essentially. All right, do I have a question? No? Okay, all right. Coming back to the anonymity considerations. Again, most host platforms feature images and names of the host. I understand that makes it personal, but remember what that does potentially to you. Along with that, public record searches can be made from a smartphone very quickly. Only an address or a name is necessary to do so. And obviously with an address, people already have what they need to find out who owns that property. So going back to how the property's held, make sure it's not a person. Because again, let's say that the address you've registered with property appraiser for that property because you're an investor is your beach house in South Carolina, or it's your personal home where your family and friends are residing. Now that person has that address in your name. So be careful what you're using and what you're putting out there. Lastly, your reputation and your safety should be protected. I think a lot of people here are real estate professionals or have other professional licenses. We're in 2022. A lot of times when there's an incident, the first people do is take to social media. I have a lot of clients ask me, Tiffany, do you invest? Do you like to partake in the market? And I say no, because I'm a licensed attorney. That comes with a bucket of ethical rules, but also I would never want someone to have an incident or to feel that I wasn't a good host. And now that's out there and that's going to fold in with my attorney reputation, right? So I stick to being an attorney. Not to say that it's a bad thing or that people shouldn't branch out and start doing other investments, but if you do, you need to protect your reputation and also protect your safety. Because I've noticed, again, a lot of people are putting personal addresses on things and their full names out there on the host website. Think about what you're giving people and be careful, especially if you have some professional license. Be mindful and protect it. Protect it while you're having this investment opportunity. Evictions. Evictions are interesting because the law is in flux. What you should know is you may need to do this if you or your client are a short-term rental host. I know it's intuitive. It's like, well, they're just a guest. They're just staying there. The reality is if you need to kick them out, obviously go through the host platform first. But you probably next need to contact law enforcement, and people have to do this. If law enforcement is contacted, they come to the scene. They are the ones who decide if they can say on the spot, order that guest to leave, or if they feel that this is actually an eviction, there's actually some tenancy here. The practical aspect of that is this. There are parts of Florida where short-term rentals are very popular, and the law enforcement will be familiar with it. They'll know it. They'll have dealt with it several times before. There are also areas of Florida where it's the opposite. It's not happening a lot. It's new. People aren't really doing this. So think about that, because it's going to be an individual decision by that officer at the scene, what they think it is, and they're going to be safe with it. So yes, there are times where you have to file a lawsuit to evict an Airbnb or a Vrbo or whatever kind of short-term rental tenant. These are my recommendations, because it's hard to get rid of that part. Have the responsible party available. So again, even if the law doesn't ask you to have that person around, have that person available and make sure they can come to the scene if you can't. So there's someone else talking to the officer, not just the guest. Be diligent about the length of stay and extensions. You know, if you're increasing the stay, if when the officer comes to the scene, the person says, well, I've been here for 3 weeks, you know, I feel like I have the right to stay for whatever reason. They're probably going to say, this sounds like landlord tenant. This sounds like you need to file an eviction. Sounds like a civil matter. Some of us have probably heard that phrase before. And lastly, behave like a landlord at all times. I have seen on the online forums, because I'm nosy, I've seen things where people say, I'm going to go turn off the lights. I'm going to turn off the Wi-Fi. I'm going to turn off the water. I'm going to entice them out of the house and then go lock the door. Don't do that. That's illegal. Again, not Tiffany, just the law. Don't do that. You've got to be mindful. You've got to be like a landlord at all times. So we're pivoting now to wrapping up with some general recommendations. But before I kind of walk through my recs, which are on the screen if you want to read them, I'm going to open up for questions. And you can put them in the chat, or you can shout them out, or you can raise your hand. I'll see you if you raise your hand. Nothing? I've scared everybody? Okay. Well, let's talk recommendations. That may make you feel a little bit better, because this is working with the bad and the ugly. You know, I ultimately am a neutral party. I don't want people to love or hate or feel afraid of doing short-term rentals. I just want you to know what can happen and how to mitigate it. So obviously I'm an attorney. My first one is to talk to an attorney. We can, just like I've done today, we can walk through specific to the property. What are your areas of risk? Okay, you have a swimming pool. Okay, you have big oak trees. Okay, you want to have large mirrors in the home. We can talk about that. And how to mitigate it. Get the right insurance like we talked about, but don't rely on it. Just be aware that this is out there and it's possible. It's rare, but it's possible. And if it happens, it can take everything you got. So think about it. And with that, retitle that property. If you or your clients are holding property in an individual's name, whether it's theirs, the business partner, the friend, grandma, auntie's name, whoever it is, we don't want that. You know, that is going to be the main area, the main path someone used to find personal liability and to reach personal assets. So cut it off, retitle that property. Preferably, again, our firm has a preference with the Florida Land Trust because, candidly speaking, we found that it's foolproof. But if it's better for tax reasons or for practical reasons or business purposes to use a corporate name, do that. Whatever you do, no individuals' names. Continually balance your risk with your rewards, like I think we've done here today, and I'm sure you're going to do it in your heads now. Think about, okay, how much can I make? How could, you know, if I get a house that's on the water, how much could that fetch me? If I decorate it really cute, how could that work for me? If I buy that cute bungalow, maybe I'll make a little bit more. But what is the risk that could come with that? Am I comfortable with it? How can I mitigate it? Or do I want to buy the house in the suburbs instead or rent that one out? You know, think about those things. Inspect the property often. A lot of the things we've talked about today come from the failure to inspect the property. If you've got, again, uneven tile, your trees aren't trimmed, you don't have that pole fence in the backyard, well, that's probably because you didn't go out and look at those things and have it inspected. Could you go hire an actual property inspector to do that? Yes, I would love it, but I know that's expensive. So at least yourself and some other form of professional, if that's not you, go out and look at that property, plug things in, look around the home, move the furniture around, sit on it after you put it together, and don't cut corners on maintenance. You know, the example of the plumber at 2 a.m. I want you to do that. But again, if you have a corporation, I want you to use the right credit card. Don't cut corners on that, because that's another big area. A lot of these physical injury, property damage things are going to come from failure to inspect. And because those kinds of lawsuits require negligence, which is a whole nother get real talk, but because they require negligence, if you're cutting back, you're doing what you're supposed to do. If it happens to you, you have some substantial defenses. With that, of course, engage in risk mitigation techniques and strategies. I talked about that our firm generates waivers. Other firms do the same thing for these persons who are doing short-term rentals. Think about doing something like that. I do not expect a waiver to fully hold up in court, but what it does is it signals to that person mentally that there's a risk here, I'm undertaking a risk. And it could come out in litigation, or it could come out with the insurance company to help you out in that regard as well. Warning signs, you have a waterfront home, there's alligators back there. The manatees aren't going to hurt you, but the alligators will. So put a sign out back that says there's alligators present. Put a sign out back that says watercraft require being aged, whatever, and up. And don't assume anything. Your guests are coming probably on vacation to have a good time. They're probably from another state. So they probably don't know about the alligators being in all the water. They probably don't know that the big pelican birds are harmless. They don't need to run from them. Those things are not going to be known by people who are just coming to have fun. So you need to take into account all of these potential areas of risk and make sure that you handle them appropriately. Because again, if there is liability to be had, if there's a claim made, your actions in trying to help and trying to prevent that and trying to keep people safe are going to do very well for you. Because again, it's going to be predicated on negligence. And every guest is not going to be careful when they come to your home, unfortunately. So that's something to think about. I think a lot of persons, when these incidents occur, they jump to, well, they should have known that. The law will figure it out for you, which you probably don't want to happen. So I am wrapped up. Here is my contact information at the firm. That phone number is the main line for the firm. That email is my email address. So take it down if you want to further this chat. Or if you have specific questions about this or other areas of real estate law. We do offer free 15-minute consultations to our realtor friends. So take advantage of those. Attorney Martinez, if she was on here, would tell you, please take advantage of that. We love helping you all and giving you guidance, especially in this new market that we're in. So while that's on the screen, I'm going to leave it up for another minute or two. And I'm also going to open up the floor to questions regarding what we've discussed. And I'm going to hang out here with you. Anyone who stays on the line, I'm going to hang out with you for another few minutes. I see something in the chat already. Thank you, Tiffany. You are welcome, Kristen. I am glad to be here and fill in for our Kristen and chat about this issue. It's a very interesting area of law. It's been fun to dig into this and put together this information for you. I'm going to move that over in case it's covering up my contact info. Appreciate the insight. And Florida Land Trust, you are welcome. We love Florida Land Trust here at Martinez Law. We've done the research on them. We have what we consider to be good paperwork for trust, and we love working with them. I think they're going to protect a lot of the investors we've been working with. You're welcome, Jody. All right, well, it's been about another minute and a half. So my email's right there, or my phone number is right there. If y'all have any specific questions or want to further this discussion, especially like I said, if you're a realtor, you're gonna get a free 15-minute consult with us. Call us up, shoot me an email, and we will chat. Next month's Get Real, you will receive the information. If you have your sign up for our emails, you'll get it there. Or you'll see it on social media. I think Attorney Martinez is still thinking of what topic she wants to do for next month, but you will definitely see it if you follow us on social media. And if you don't already, you should. There's fun and funny stuff on there, and there's serious things too. All right, well, I'm gonna stop sharing my screen. Still got a couple folks here. So, oh, I see a question here. How much is changing from personal name to land trust? Our firm charges $750 to generate the land trust, and we charge approximately $250 for the quitclaim deed. Some people will have doc stamp taxes on top of that, but approximately $1,000 all in to handle this with us. All right, it's 11:34. So again, if you all you're welcome. If y'all have any specific questions for me, reach out to the firm. We are here to assist. Other than that, y'all have a great morning and afternoon and lunch break. Bye-bye. Thanks for joining us.
Thank you.
You are welcome.